Episode number 2. I'm excited. I'm always excited to talk with you, but this time, recorded. Let's just redo our intros briefly. If you want to go first.
Sure. Chad Tourin with Coastal Wealth. I have a practice of working with business owners and high net worth individuals, guiding them along their path with stuff that's financially related, not financially related, but making sure that they have a complete plan that will not just hold up today, but hold up in the future as well.
Great. So Barry Haimo here, Haimo Law. We help families and businesses with their estate and business planning, which deals with wills, trusts, probate, business planning, asset protection, trust administration. It's a niche practice, but it's a big universe. I'm really happy to get to sit down here with Chad today. This is day 2, recording 2. I guess there's now 16, but we reserve the right to add more before we're done. So we left off, I think we said, with not having this shareholders agreement / buy sell. I have in my notes here, it says divorce instead of divorce. And in parentheses, divorce, bankruptcy, death, disability. We briefly talked about that already. So let's just recap real quick, high level. In your opinion, why not having a shareholders agreement or a buy sell is just a colossal blunder?
Well, one is it's something that can be proactively, but blunder can be avoided just by doing a little bit of planning. And by a little bit of planning, we talk about shareholder agreements and buy sells. Most times in your business is your baby. It's going to be the thing. It's your retirement nest egg. It's the thing that's going to spit off income for you and your family. Without having these shareholders agreements, should you ever leave the business, whether it's on your own terms, because you want to, or some sort of illness or death, unfortunately, even death occurs sometimes. Without having an agreement in place, one, your family may never receive the value that you built in the business over time, because there may not be a way of them extracting the value out of the business. The other partners may keep it. Another issue is that control of the business, if the situation is reversed and you're the business owner with a partner whose spouse may have passed away, well, without the proper shareholder agreement in place, you very likely will be stuck with that deceased partner's spouse as your new partner. And that really complicates things when they may not be a part of the business. They might not have any idea how to run the business, but yet they'll have an equal say in the decisions that are being made for the business. And that's really one of the biggest issues I've seen.
Okay. That was not brief, but thank you. So if I were to try to
get fired up on, so it's hard to stay brief for.
That's right. It is bold. It is bold. I forgot. Bold on our list means that we get excited. So expect a longer, more lengthy response. My 2 cents of that would be, life happens, and if you just think about your own life, all the different things that can and could happen and have happened. A lot of it's been unpredictable, and that's the same that's going to happen in a business. And with divorce, bankruptcy, death, disability, partnership disputes, you want to make sure those things are agreed upon in advance when everybody's happy, when everybody's excited and optimistic in the beginning. That's turn my phone off, because that's when people are going to be able to make the most sensible thinking about how these things will be resolved. If you don't resolve them in advance, then the rules are either one of two things is going to happen. The rules are either designed for you already by statute, which are usually not pleasant, or you're going to litigate the crap out of the case, and you're going to spend hundreds of thousands of dollars to get a desirable result, which will end up most likely being undesirable.
Exactly. To me, it's no different than not having the proper estate planning documents. If you were to become incapacitated, you don't want the state making the decision of who's going to make the healthcare decisions for you. You want to predetermine who's going to make those decisions. And, you should similarly want to predetermine what's going to happen in your business should something go awry, and stuff does seem to go awry inevitably at some point, and it's just something that you can very easily avoid.
Well, you brought it up, so we're gonna go there now. Yeah, estate planning and just like business planning, you either make the decisions yourself now while you can, or those decisions will be made for you by somebody else. You say the state, but really it's not the state. It's actually like a man or a woman judge who's going to decide that for you. A third party stranger is going to make those decisions for you. And those decisions can have a big impact on your family. And in this context, your business. So, yeah, we're both, I think, pretty fired up on the shareholders agreement buy, sell. They're critical. Do them early, get them done, or
Probably
have a really good litigation start of
separate
your.
separate webinars on those just because it's such an important topic, I'm
I
sure.
would love to do that. I would love to do that. And what we could do is we could bring in a litigation attorney who does, commercial litigation, and we can have them talk for an hour, interview them for an hour on how much money is going to be spent when the partnership, dissolves, or I shouldn't say dissolves. That's a term of art, but blows up. Better word.
Right.
Partnership blows up. I mean, we're talking about a fortune. So we'll get somebody on here for that too. Um, let's see. Number 9. Um, which will admittedly sounds self-serving, is not having professional advisors and those advisors not communicating, or if you do have advisors, not those advisors not communicating amongst each other well, I guess.
Yeah, I
What do you
mean,
think about that one?
there's numbers in a sense. What prompted us? I mean, we enjoy working together anyway, but prompted us to really have this dialogue, because there's a lot of, let's start with just the professional advisors first. There's a lot of free services out there. There's LegalZoom. In the investment world, you have a lot of robo advisors out there now where you can just go on and make your own investments. But those people aren't, there's no backing behind those systems who are educated in those areas, or they're very generic. You can't really customize them to your particular situation. And so not having a professional advisor who specializes in the client's particular situation, because no situation is alike, could be detrimental. And with regards to the advisors not working together, this is a big problem because I run into scenarios a lot where either I'm the investment advisor and they have an insurance person, or I'm the insurance advisor and they have an investment advisor. And both of us may be doing the same, can do the same work and can be giving the client different advice. So if we're not communicating, not only are we going to be more likely confusing the client, the advice can be contradictory, and, a lot of times when there's contradictory advice and the client is confused, they decide not to implement anything whatsoever, which is, just as detrimental as implementing the wrong thing. And also with respect to working with, an estate planning attorney like yourself, our worlds are very interrelated. There's a lot of times where the estate planning attorney will work on the legal side, but need financial vehicles in order to, implement some of the things that they're trying to do on the legal side, and vice versa. And so having the advisors sit down in the same room together, or nowadays the virtual Zoom room, it just creates confusion. It could create duplicity, and create what could be a simple situation much more complex than it needs to be.
I would piggyback on that by just saying that philosophically we view this stuff as a team sport. We don't want to work with people who are going to silo themselves and not collaborate, because it all is interrelated and it doesn't do the client a service. It does them a disservice if everybody's working independently and not communicating with each other about your planning. Um, so we try our best. Not everybody's on the same page about that.
And no one can be a jack of all trades. I have my CPA license and my law license, but I'm not doing the tax prep work or the estate planning documents for my clients. There should be people on as our team, that specialize in those areas. And
That's
so I
yeah.
think that's important also.
Similarly, I have a master's of law in tax. I speak tax, but I don't prepare returns. So I wouldn't, I wouldn't give the type of technical advice that I would rely on when talking to a CPA. So
Exactly. And CPAs are very important to be part of the conversation as well.
yeah, yeah. Um, that's a quick one. I mean, it does sound what it is, but we do, you and I do, I think, agree that it's a trifecta. It's a team sport, and it's a mistake to think otherwise and just go, with one of these professionals that are not talking together. Number 10 of Chad's top 10 is businesses that go through probate. Um, why is that significant? And I would like to chime in on this afterwards, but why is that significant to you from your perspective?
Um, and I think you'll definitely be able to elaborate on this one, as well on a little bit more. But from a planning standpoint, if the business owner passes away and that business is that family's biggest asset, if it's going through probate, that family, the surviving family, is going to be left in a pretty horrible financial situation unless they've done appropriate planning elsewhere. But even with that, there's no reason um, for a business to go through probate when it can be avoided just with some planning, similar to the shareholders agreement, the buy sell planning, and the exit planning.
That's true. Not bold, not exciting, but unfortunate reality that when a person passes away and they own the business in their name, it's going to go through the court system. And I think we should do a whole nother breakout session on this, by the way. I have a lot to say on the subject, but going through the court system in a probate is a long and unpredictable process. And it's going to divulge a lot of information about the business, to a lot of different people, almost public. Um, it can be avoided. It should be avoided. It will definitely disrupt your business and distract you from your focus. And the family who's waiting on that money is definitely going to be sitting around for a long time, wondering what's going on. So even businesses that have no money that are insolvent, I've seen last a year because of complications to get
Yeah.
to the person they need to be. A year. And didn't even have any money. Took a year for complications. And this is pre-COVID, by the way. We have new number 11, which we added last time. It's bold. We both get excited about it. It's an interesting issue. And it's the subject matter of a lot of games and how the law changes and games get played. So, number 11 is characterizing or mischaracterizing employees slash 1099s, independent contractors. Um, what's the big deal? Why can't we do that?
you know, a lot of business owners when they're starting out loves to categorize people as 1099s, independent contractors, because they don't have to pay payroll tax on them. And, no Social Security, no Medicare, and we find that's why business owners do it a lot of times. But the IRS will eventually realize that if someone should be characterized as a W-2 employee and you're not doing it, they're going to come back and come after you a little bit. And financially, there could be a lot of unnecessary penalties and taxes that you're going to owe down the road that are a lot more severe than you would have incurred had you just done things appropriately from the get go. And the rules relate to how much the employee works, and there's a lot of I'm sure you can elaborate on the legal requirements in terms of the classification distinction between the two. But financially speaking, it could really harm the business down the road in terms of depleting cash flow or other assets of the business to make up for their error.
Yeah, I think that I agree with everything you just said. You can't you can't just choose what's convenient. To go back, I think we mentioned in our last video, the law changed with the Affordable Care Act that businesses were required to carry insurance if they were of a certain size. I believe it was 50 employees or more. And so people started to, I guess people around, give or take what, 10? Can't be too obnoxious with it, but I guess, around 50, give or take, plus or minus, they started to recharacterize their people so they wouldn't have to carry the insurance because it's a huge, financial commitment.
Yep.
And, aside from the general gamesmanship that goes on just to, minimize taxes, that was a big driver that kind of put it on the radar. So we could probably do a whole session on this too, and probably should. Um, you know, the IRS looks at it from a substantive point of view. They do not look at it by what you call yourself or what you write in a contract that you are.
Just
They're
give
gonna look at
flashbacks to first year of grad school when all they talked about was substance over form. So
Yeah.
you're bringing back my lovely memories back at US.
I love about the law that nobody else loves about the law, but I love about the law that it's substantive. It's really like what's the essence of things, not so much like what's on the surface. And so when you look at a person and their relationship with a company, you can put aside the labels all day. What do they do? How do they do it? When do they do it? Where do they do it? Um, under whose direction, control, equipment, just there's so many different levels of analysis that goes into it. And of course, if it gets audited, it's like a colonoscopy and it's going to be unpleasant. So
But everyone knows how fun those are.
I will not speak on that one. I will not speak on that one. But the bottom line is that yes, at the end of the day, there is savings if you're a contractor in terms of payroll taxes. I think it's just round numbers, 7.5% per employee and the employer, right? So 15% is
Give
the
or take.
difference. Um, you know, there's penalties, interest, and it's a crime if you don't
Now, payroll tax is
do
an
it.
interesting topic right now with the executive order that's currently being proposed and what that may do to businesses next year who don't account for things correctly and what that might do to people who think they're getting bigger paychecks now who will likely have to make up for it next year.
So number 12, I get excited about. It's bold. Um, as a reminder, bold means excited. Number 12 is entity selection. Um, entity selection. So to me, there's a lot to talk about,
Yeah.
but I like to give Chad the first crack at the apple
Oh,
every time.
we'll try and keep this really high level because there's a lot of different things that go into entity selection, both from a financial and a legal standpoint. From the legal side, obviously, the different entities differ in terms of liability, exposure. They differ in terms of control that you have in the decision making process. And and there's a lot of other things as well in terms of raising capital, etc. Financially speaking, one of the biggest impacts is on the tax side. How the entity selection could affect um, you know taxes, both whether you're paying self-employment tax, which typically if you're an LLC, without making any sort of other tax election, you're going to be paying self-employment tax. um, there is maybe you want to chime in on some of the legal side um, of things because it is predominantly legal driven, I think, in terms of the entity selection, in terms of liability, bringing in partners, how the accounting for capital contributions and all of these things really can play out.
I don't think it's all legal, actually. I don't. I think there's a lot of dimensions to looking at it. I think that people, unfortunately, they knee jerk into doing it themselves because they can in today's world. They can do it themselves. No offense to you as a CPA, but I find CPAs tend to knee jerk their clients into things that they're more familiar with, and not always necessarily the right and appropriate entity. And sometimes that's really hard to fix.
It's
So
probably because they can't keep up with all the different variations of LLP, LLLP, LLE, and you can go on and on with the different variations of the limited liability arrangements you can set up.
yeah, there's a lot, but I like to think that we can keep it simple depending on the needs and goals. I think if you just start with the needs and goals, I think that the the pool narrows tremendously. So I would characterize kind of the dimensions of formation. And again, we can keep it high level because we'll do a breakout. Um, I would call I would talk about legal in terms of limited liability. Everybody knows about that. That's why people form companies mostly. There's
And one
different
thing
types
everyone
of
can probably agree on is don't be a sole proprietor.
yeah, don't do that. Don't do that. Don't be a sole proprietor. People form companies because they want the limited liability of the business. Someone slips and falls in the business, they're not going to sue the owners, the shareholders. There's a whole another element of liability exposure that businesses can help address, and that's the asset protection of the shareholders who are exposed to claims from creditors that have nothing to do with the business at all, just because the business represents an asset to them, and that's beyond I think the scope of today. But it's definitely an area in which we play in a lot, and we'll get to it later another time. But basically, limited liability in the general sense of separating the shareholders from the business is a common driver. Um, it's common to think tax. I think is a big driver. Um, Minimizing payroll tax liability, capital gains, stuff like that, holding periods. There's allocations of profits and losses, distributions, which are more flexible in certain entities than others. Becomes more relevant when you're raising capital. When you're raising capital, is a whole other dimension to it, where you want to structure the business in a way that facilitates multiple rounds of raising capital, and usually that comes along with different tiers of management and control, and then that lends itself to a discussion of management and control. When you go into a business with a partner and you don't have an agreement, you don't have anything set up. The law is gonna characterize you in a certain way, and the tax code is gonna characterize you in a certain way,
Yeah.
and you have the ability to change all that by just doing some thoughtful planning in
And then
advance.
we have a general theme developing here that
What's that?
you can control what you want to happen down the road just by planning ahead of time as best as possible. Obviously, you can't control everything, but you can prepare yourself.
I've been working on a really good image for my social media on this concept of choosing that I'm excited to post. I haven't done it yet, but yeah, it's all about control now or roll the dice later. That's what it comes down to. And I gamble. I'm a poker player. I play blackjack. I understand odds and I understand probability, and I'm trying to impress upon people the connection between odds, probability, gambling, and risk with
And
planning
we're
ahead.
going to our plans for the risk.
Yeah, plan ahead. So to recap, entity selection is driven in large part by legal limited liability, minimizing tax, dealing with control, um, being flexible on how you're structuring, profits, losses, distributions, things like that. Um, Raising capital, and I would kind of nestle underneath tax the things like 1202, IRC 1202, which can have a substantial effect, financial effect, or economic effect on the sale of a qualified small business. You can have substantial benefits because you will recognize less tax, but it's very complicated, far beyond the scope of this video. The point of making is that there's so many ways to look at it that it's just not so simple as you go on Sunbiz, you form it in 10 minutes, and you're done. You're done, but you might be setting yourself up for a problem later.
Yeah, I'm sure you see that a lot also. If someone develops an LLC and then they don't create an operating agreement to go with it.
Or they do create an operating agreement, but they got it from online, and it's toilet paper with some writing on it. And in fact, I gotta be mindful of what I say here, but I am involved in litigation right now, um, representing a client who the main issue is the operating agreement. Just it's a terrible operating agreement, and there's ambiguity on what certain things mean, and those ambiguities have real impacts on how the business is being run. What are the rights of the shareholders? And guess what? A lot of money is being spent on fixing this problem, and there's a lot of lawyers. There's a lot. It's already taken a lot of time. And it's sad because all this stuff should have been done right the first time. So, yeah, great point. Great point. Did I mention I mean, I didn't really mention the types of entities. I mean, just to kind of throw out the spaghetti at the wall, there's the what you mentioned, the sole proprietor. That's like the lemonade stand you don't incorporate. You got your C corp, and you got your S corp. But and I'm sure if you wanna chime in, C corp,
Mhm.
S corp legally are the same. Tax-wise, they're different.
Correct. The S corp is really a flow through entity where the profits and losses flow through to the individual owner, and that's where they pay tax. They only pay tax once at the shareholder level. The C corp actually there's double taxation because the C corp as an entity pays tax, and then when the dividends and distributions go to the owners, they have to then go ahead and pay tax on that again. And don't really want to get too much into which one's the right one or wrong one because it's really a case by case scenario, especially with the lower corporate tax rate that we're in right now. But it's really a case by case analysis and um, decision client by client as to what the right route to go is.
Yeah, it's true. The corporate taxes are much lower than they used to be historically, and that's a consideration, as is the double tax. Like you said, it's facts specific. There's no canned solution. Um, I just would mention that there are benefits to forming a C corp. It just depends on what you're doing, what your goals are, and what your vision is.
Yeah, as a C corp on the financial side is actually a lot of things that the business owner can do planning for themselves with through the business, and receive tax deductions that for the business that they normally wouldn't be able to receive with an S corp. And like, we can touch upon this later, but there's a lot of different things like executive bonuses, for example. The owner of a C corp can give themselves an executive bonus and receive the deduction for it. That's not the case with an S corp. So everything kind of needs to be looked at as a whole with all the different factors and not just one at a time.
Yeah. So we have sole proprietor, C corp, which can elect S. We have LLC, and I'm a big proponent of LLCs, which are relatively new. Relative to the length of time that the
You could
C-corps.
also elect S or C status on from a tax
Yeah.
standpoint.
Well, I always say you can do LLC, 4 ways, because you can be disregarded, you can elect S or C, and by default, if you have multiple partners, you're a partnership.
Right.
So they're really flexible. Um, and that brings us to partnership, which really should have come after sole proprietor because it doesn't really have a formal, incorporation. So if I could do flashy light thingy from Men in Black, I would do that and start over, but I can't. So, partnership is just 2 people that are, in business together, and, you have a business, and there's liability, there's exposure, there's rules, the whole body of law governing that relationship.
Yep.
You looked like you were gonna chime in there.
No,
Uh,
no, no, no.
so partnership, like sole proprietors, are ill-advised. Don't do it. There's liability. Don't do it. Why do that? But it is an option. So sole proprietor, I'm gonna fix my mistake. Partnerships, general partnerships, C corp, which can elect S, LLC, which can elect multiple things, or has defaulted to a couple things. Then you have limited partnerships, which is LP, limited partnership, historically used for tax planning. Back in, I guess, pre 1986. Um, a lot of cool things you can do with LPs that we can talk about another time. But basically, those are structured in a very particular way. They're different from corporations and LLC.
Very popular with law firms, big law firms. You see a lot of LLPs, right?
Well, no, those are LLPs. So LP, that's where you get the L's. There's a lot of variations of that as L's. LP is just a general partner, limited partner, where the limited partners are just kind of riding along on the wave. They have no managerial control, and general partners can completely control of the business, but also has 100% liability exposure with the business, which is why usually you have another entity serve as that general partner. Um, and there's a lot of good things I could say about LPs, except they're expensive, and there's no need for them anymore with the advent of LLCs. LLP and LLLPs are where you get your law firms and your CPA firms, and the idea there is that uh, you can kind of insulate liability among partners much better than you can as a general partnership. And then at the same time, you can be involved in the business, unlike an LP, which is mostly made up of limited partners. So there's a lot of ways to do this. And, control, financial, tax, structure, raising capital, you know, just really thinking through the vision of what you're doing is important. So I can talk about this all day. So we should probably, move on, right?
We'll add it to our list of individual webinars here.
Yeah.
Anyone, you're getting good at list making, Barry.
If nothing else, we're developing list building skills. I agree. Next thing on the list is bold. I'm I'm passionate about this issue. I guess you are, although we don't really have like a joint bolding um, mechanism in place here, so I'm not sure who did it. But basically, the next one on the list is exit planning. So I want to ask you this question: what the hell does that mean?
Well, everyone's going to leave their business at some point, whether it's because you want to, because you're forced to, or when it's not your choice and it's due to death or disability. And to me, exit planning really comes down to, do you want to receive the value in the business that you built? And if you don't proactively plan for that, businesses are very illiquid most times, especially when the economy is not doing great. Not many people are wanting to buy businesses, and if they are going to buy it, it runs into the issue of, okay, well, what are they going to do to my business now? That kind of will, I guess, leads us to the next bullet point, which we'll talk about after, in succession planning. But exit planning to me is really extracting the full value of your business, and how do you go about doing that? Receiving the full value in a very, very oversimplistic way of thinking about it.
That's pretty well said. Um, I would characterize it as like when you think of like going public, right? You know, what that really means when you say you're going public is that you're going to hire an investment banker, an investment banking firm, and they're going to work on your business to package it and make it as shiny and beautiful as possible. And what that means in this context of a business is they're going to make sure that everything's buttoned up tight and it's operating efficiently, effectively, and there's as little loose ends as possible. Um, and so what we're talking about with exit planning is just a non-publicly traded, like a small, closely held business scenario where we're come in and you help a business to really tighten up, fix the issues, identify the issues, fix the issues, and get them in a position where they can sell in what, 3 to 5 years, you'd say? A fair short-term vision. You don't engage in exit planning for a 20-year horizon. You engage in exit planning on a short-term horizon, but it takes time.
Important to do it definitely important to do it a few years out, without a doubt.
Right, right. So say if it was a car, I'm making this up as I go. But say it was a car, the business is a car. You got to repaint it. You got to open up the hood. You really got to see what's going on under the hood. You got to fix it, and you got to really, look in the interior. You got to make sure it's all repaired and it looks good and it's functional, and that what you're representing the car is and does is correct, is accurate, and that if you're representing
It's like
this
selling a
car.
car, and you don't do all this stuff at home, and it doesn't appraise at what you sold it for. You're gonna be in a bad situation.
The car could have a defect that you either know about or reasonably should know about, and boy, is that gonna bite you in the butt when the buyer buys the car, it's nice and shiny packaged and has a ribbon on it, and it blows up, in your face. So that's kind of what this is talking about is really maximizing the value in a later date, but a short-term date. The alternative.
Yeah, and as a side note, it's really
Yeah.
important for businesses to get professional business valuations done. We talk about exit planning. You can't exit if you don't know what your business is worth. And there's lots of different ways of valuing businesses. I know this is kind of a side note, but I think it kind of goes hand in hand with exit planning. Is you can't be looking for purchasers of your business if you have no idea what your business is worth. And so, the exercise of going through and getting business valuations done, especially when there's changes in the business or rapid growth in the business, it's no different than an estate plan. If there's a life change that happens, if you get another kid, if you get married, you got to update your estate plan. Well, if your business doubles in revenue, you should probably get your business another business valuation done.
So, is it worth $20,000 to do a valuation somewhat regularly?
I wouldn't say necessarily need to do it regularly. Really, it's worth it when there are significant changes. I had a client whose revenue literally doubled from 25 million to 50 million over a 2-year span. And the buy sell plan that I did for them, was based off of one valuation, and it needed to be revised. There were changes in the business. So it's not even necessarily revenue change. There could be changes in the business in general that you need to have those updates done. So I wouldn't say it's necessary to do it every couple of years, but if you're looking at the difference, even if your business went up 40%, that's still a significant change where it might be worth spending $20,000. But also, like you said, you want to start thinking about these things, the 3 to 5 year window from maybe when you want the exit to occur. So I think the closer you get to that point, I think the $20,000 cost of evaluation becomes more important. I don't think it's important necessarily for companies in their infancy to do it every couple of years, but when you get closer and closer to maybe wanting to exit your business, then it becomes more important.
Without straying too far, I do think you make a good point worth talking about. You're tying the valuation to something that has meaning, that's substantial, being your buyout planning, your disability buyout planning, your death triggered buyout planning. Um, that's tied to contracts, and if you double in value, you need to cover that, and your gross.
I'm not gonna jump ahead to the importance of contract language. We'll save that
I
one.
was trying to be mindful of that. But now you're grossly underfunded, under whatever the word is. You don't have enough coverage to properly execute on those plans. So you have to. So in that case, it's tied to something that's really critical. Another thing it's tied to in estate planning is, say that your estate plan say you have a couple kids, three kids, 4 kids, whatever, and maybe one's in the business, one, 2 are not in the business, and some are getting the business as their inheritance and some aren't. And the value of that business, needs to be addressed because it's the intent is to be fair. They should get the same amount as the other one, the business owner, the business inheriting child. The valuation becomes very important there, and there's ways to build that in so it is as fair as possible.
Yeah.
There was another really good reason to do valuation that you mentioned that was tied to something substantial. The funding of the contracts is one, the estate planning is another, and I forgot the other one, quite frankly. It will come to me though.
The good thing is we'll have more of these coming. So
Oh, it will come to me. It will come to me. It's relevant for succession planning too, which is the next thing on our list. Um, so exit planning, just to recap, is I know what I was going to say now. E- Exit planning is really important. In the short term, 3 to 5 years. Packaging it, fixing it. It's not so much what I do, or I would say you do, as much as it is getting the team in place to work on it with a common vision and a structure.
that one is very much a team sport, as is all of this. But having the legal side, the financial side, the valuation side, the tax side, all of that needs to come together with exit planning. And so having the full team there is very, very important.
Right, and I would only just add one more thing to be clear on exactly why it's so technical. On the legal side, you're gonna wanna look at, like, every contract this company has in place, every person that they have in place, the contracts with those people, the IP, is it protected, is it not protected? Are there litigation pending? Is there litigation reasonably likely to be pending? Are there are there formations, filings, you know, licenses, everything? Is it in order? It's a lot of work just for that. That's a ton of work, you know?
Yeah.
If it's not fixing it, then you got the tax side, which Chad can speak of, but you also have the operational side, like who's doing what? You have the right people doing the right thing? Is there fat in the business that needs to be cut? Is it efficient? Is it optimized? Um, do we need to improve the business from a purely business operational standpoint? Is there technology that's needed that would help displace certain people and costs? If you want to speak on the tax side, just kind of briefly and the financial side to review what they have as well.
Are we talking about we move on to the succession or still kind of on the
No,
exit
just
plan?
just exit planning, just to kind of give a little bit of depth to why it's such a comprehensive area to focus on.
Well, from the financial side, a lot of times if you don't do the planning ahead of time, there may not be the funds available for the business owner to exit. And they may end up being tied in their business for a while. It kind of falls in with succession planning also, where if you don't have the right successor for your business, you're not going to turn it over. You're not going to exit. And so there's ways to position yourself financially speaking, to almost pre-fund your exit. And there's different vehicles that you can use to do that.
By exit, by the way, I don't think we define exit, but exit means to sell
Yes.
to either one or more parties, whether you hire a broker.
Yeah, you can sell outside, you can sell inside
Right.
to insiders, you can sell to family member, which you mentioned. And so that also comes down to planning, having those conversations about who do you envision selling this to one day? Because that can dictate the type of planning that we do.
Great point. So if you were to want to give your business, if you're an owner, you want to cash out your business, and you have kids that want to be in the business, it's an interesting concept as to whether or not you choose to sell to a third party and let your kids figure it out themselves how that works, or maybe sell to your kids, or give it to your kids as part of succession planning and estate planning and tax planning. These are the conversations that we have, right?
Yeah.
And there's no canned solution.
There's no right or wrong. I mean, there is wrong, but there's no right way to do it,
There's
or
room.
set in stone. There is wrong that can be done, but yeah, everyone's preference is probably the right way to position it. Everyone has their own preference in how they want to one day exit the business.
Yeah, I would say in my experience, I don't think that there's ever been one that was exactly the same as another.
Yeah.
You know, the planning, the succession, the docs, prep, the conversations. Um, the only other thing I wanted to mention was with exit planning was, when it comes to estate planning, say you have husband and wife, and husband is the owner of this business, it's doing well, and there's no planning. Shocker, it happens. Husband dies
Okay.
abruptly. Wife is not involved in the business. She's not equipped to run the business. There's no succession plan. What do you think happens in that case?
The wife most times runs the business to the ground, or her surviving spouse. They're not well equipped. They don't know how to run it. It's and whatever was built by the deceased spouse, the legacy kind of goes away if there's not the planning is not done.
Legacy is the key word there. That's one option. Another option is with a fire sale.
Yep.
Fire sale. I see fire sale being much more likely.
That's Wayne Huizenga getting the Dolphins for as cheap as he did. You know, everyone here in South Florida probably knows the Joe Robbie story, and you know, there was not proper planning done, to say the least.
Tell them a Joe Robbie story.
Um, you know, to my recollection, Joe Robbie owned the Dolphins, and when he passed away, the family didn't have the liquid funds available to, um, you know, in a broad sense, there's a lot of nuances, but they couldn't afford to pay the estate tax, and that needs to be paid within 9 months of date of death, and they had to basically fire sale the Dolphins to Wayne Huizenga for really pennies on the dollar. Um, and I don't know if you want to elaborate on that a little bit, but that's the gist of it is that they didn't properly plan and they didn't have the funds available to pay what they needed to pay.
So fire sale is when a surviving spouse doesn't want to deal with the business. They just want to settle up the estate and move on. And that means selling the business for basically like Chad's a really good example of a very, famous asset that was fire sold. And so that means selling the business for fractions of a dollar. It is basically the opposite of what we're talking about in terms of exit planning. It's the
Well,
opposite result.
yeah,
It is
exactly.
right. The polar opposite result of planning ahead is to sell it quickly, without packaging, without doing the work for as little money as possible. So succession planning ties in, which is the next thing. It's bold. I get excited about it. Stop me if I'm talking too much. Succession planning is kind of like what we're talking about, where instead of you wanted to have a sell or exit to a third party or family member, you want to keep the business going, right? So you want the business to continue to the next generation. Maybe that's your family, maybe it's not. But if you don't have the right planning in place, you're rolling the dice. And it's very likely, I will go as far as say it's very likely you are not going to roll the numbers you need to roll.
Yeah,
And
and
that
it's
business
especially
fail.
for when there's multiple partners or shareholders, it's even more important, I think. Um,
Yeah, I would agree. I would agree. So how would you introduce the concept of succession planning?
well, for one, you hit on it is, okay, I want the business to continue. Um, the question really becomes is, who do we want to continue it? And how do we give them control of the business without financially hurting the cash flow and the day-to-day operations of the business? While receiving your fair share without depleting the business. And so there's various funding mechanisms that you can do, most typically through insurance, to really work on this succession plan. It's very easy when one of the easiest is if you're turning it over to someone inside of the business because you can set up um, executive bonus type plans or whatever it may be to build up a reserve to maybe buy you out so that person can take over the business. That's very common. Um, it's all about pre I want to say pre-funding for what you want to happen. Um, putting the right instruments in place, the financial vehicles in place to keep your business afloat. I think the succession planning is more about how do we effectuate everything without depleting the cash of the business and hurting the business.
Right. So how does that translate to, so many different ways like it could happen. There's so many variations. Say for the sake of argument, it's a third party that like, say you have a number two. You got a number two is great. And you want them to continue the business for the next 50 years after you go. It's not a family member. It's not part of the estate plan. How do you, what do you do with that? How do you do it? How do you deal with that?
Well, one, you have to have the correct legal documents in place, which is in your wheelhouse. But two is you can start um, funding for that transition in terms of because most times the key employee probably doesn't have the money to buy someone out of the business and then still keep it running. So really, it comes down to um, trying to get the right way to word is assisting with the process ahead of time, while you're still in charge.
Well, you're gonna address disability and death, um, of course,
Yes.
and that's a funded transaction to make sure that the business can continue to go on without having to financially burden it.
Right. I mean, the perfect example is, let's say one partner gets disabled and they can't work anymore. Well, if you don't have the disability buyout in place, well, that business is still going to have to keep paying that partner, or that shareholder. And, you know, talk about fire sales and pennies on the dollar. You can effectuate these buyouts for pennies on the dollar just
Right.
by implementing the correct disability policy or life insurance policy.
If you don't, so yeah, if you get disability or death, you have a policy, it will fund the transaction of, where the family gets paid in exchange for their shares. Those shares go to the person or people who are intended to continue the business, and that's fine. That's one way. That's one thing that could happen. But what about where you have a person who wants to kind of retire? There's no retirement triggered contract, insurance contract. So yeah, disability and death is one thing, but retirement during life is another whole animal to deal with. A lot of times in estate planning, I get this scenario where you got these people who've built something, and a lot of times their kids are kind of involved in the business, and they want the kids to kind of move it forward, and they want to retire. So they want to downshift, they want to pull back, they want the kids to push forward, and we start talking about the transition or shift of control. We talk about the timing of taxes I'm sorry, timing of transfers, which of course is very heavily, you know, related to tax. And and it's definitely hard conversations, because you're kind of juggling a bunch of different competing things. The idea though, in the purest spirit of it, is that they want an annuity. They want a business that pays them an annuity for life, and they want to figure out how to structure that. It's not a death triggered buyback. It's not a disability triggered buyback. It's a lifetime, transition,
Yeah.
retirement, with, of course, those other contingencies built into it as well.
So the next one really revolves around observing corporate formalities to preserve the limited liability of the entity. We touched upon one of the main reasons people form entities is for the limited liability that comes with it. And but as we also said, there's substance over form that gets looked at a lot of times, and there's many ways that you can do what's called piercing the corporate veil. That's really what this is referring to. Financially speaking, one of the most common ways is the commingling of business and personal funds. That all of a sudden can open yourself up to more to liability exposure that you normally wouldn't have been. I don't know if you want to elaborate on some other ways that you can pierce that corporate veil.
I do. The landmark case of piercing corporate veil was Dana Hiley. I think we talked about this last time.
Are we finishing again?
Was Dana Hiley? Remember that? Can you hear me okay?
Now I can.
Okay. Dana Hiley was the seminal case of where piercing the corporate veil became kind of, an issue. It's because I think they wholly owned the.
Frozen there.
What's that? Can you not hear me
I
okay?
think we were frozen. Yeah, we're back. It said we were frozen, but we're back.
Yeah, my connection is apparently not good. Um, Daniel Highlight was the seminal case where they wholly owned um, the valet company, and the valet company, really hurt somebody, and they sued everybody, and Daniel Highlight was able to be gotten to through the parking company because they were not doing the right thing with their company. They were not observing the corporate formalities. Bottom line, first of all, this should not be bold. This is not a passionate subject. I'm unbolding this. Uh, Observing corporate formalities, like you said, you want to have separate books, you want to have separate accounts. Don't commingle funds. You know, don't use your business to pay your electricity bill unless it's a business bill. Um, that's just common sense stuff. But have your meetings, file your reports on time, um, have sufficient insurance, have enough money in the bank. Um, the bottom line is if you're sued as a business, a good lawyer is going to unearth deficiencies in these areas that will threaten you as a shareholder kind of being brought in personally. So don't think just because you have a company that you're safe no matter what you do. To go back to what you said, Chad, it's substance. It's substance over form. So go back to law school, thank your professor. Substance over form rises again in importance today
Yeah.
in our session. So that's all. It's just very simple. There's a lot of things to do. Do it right, or else you're kind of invalidating the whole reason that you did it in the first place. Number 16, insurance policies are contracts. At the end of the day, they are contracts. And no, they are not all the same. Um, I'd like to say one thing about that before you jump in. Um, I doubt that the people even listening here have even read their contracts, their homeowners policies, their autos policies, umbrella policies, legal malpractice, medical malpractice, cyber. Have you really read the contract? Do you know what the hell's covered? Do you know what's excluded? Not these policies, every single one is unique and you get what you pay for. So be careful when you get exactly what you're asking for because sometimes you might be getting screwed. To you, Chad.
And, to add to your list of things that typically aren't reviewed, I have some clients that haven't even reviewed their employment contract, and seeing what the nuances in there are in terms of non-competes and different things like that. But when I talk about insurance contracts, especially disability insurance contracts, I I liken it to an employment contract. An employment contract dictates what happens while you're still working, right? You want that contract to be as airtight as possible, as much as your favor impossible. The disability contract is nothing more than an employment contract if you're ill or injured to work. Because disability insurance
Oh my
is
God.
really nothing more than income protection, right? When people think disability, they right away get that handicap sticker image in their head of someone in a wheelchair. Well, 9 times out of 10, it's not. It's someone who's ill, someone who could be sitting here having this conversation just like we are today. And so it's important to make sure that that contract, the language in that contract is as much in your favor as possible. So here are some things, quick tips that come to mind where language matters. One, is your mental health covered or not? There are disability insurance policies out there now that will only cover mental health for 2 years, but there's also ones out there that cover it for the entire length of the contract. And that is something that you can determine. That's another contract language. You get to determine how long you want your benefit to pay for, right? So you can have benefit pay for as little as 2 years. You got benefits go all the way as long as lifetime, right? And not knowing what you have or how it's structured really plays a role. Another area where I see contract language really differ is in terms of the elimination period, which for people listening in is really nothing more than the equivalent of a deductible on your car insurance. You can have a $500 deductible and pay more than the person that has $1,000 deductible. And we can have an entire other conversation why I don't understand why anyone has a $500 deductible in the first place. But we can I'll save that for another time. But with elimination periods, you can have a 30-day elimination period, which is what your benefits would start after 30 days. You can stretch it out as long as 2 years. And if you don't know what your elimination period is, and let's say you have a 2-year elimination period, meaning your income is not going to be replaced for 2 years. What happens if you have no other source of money and you're out of work for 2 years? Your whole financial plan can blow up. And so it's really important to look at the contract language. You mentioned what's covered and not covered, right? These policies are not all issued equally. Someone may have a clean policy, which means nothing is excluded at all, while another person maybe had knee surgery when they went skiing one time, and they're a doctor who's on their feet all day long, and now their knee is excluded, and they don't know that if something happens to them and it's their knee, that they're not going to receive benefits. So really knowing the contractual nuances is important. Um, I think until I get fired up. Um, the, especially because the most common answer I hear, if you're not a business owner, the most common answer I hear when I talk about disability insurance is I'm all set. I have it through work. I hear it all the time. But there are so many contractual nuances in your employer group disability plan that you may be thinking your income's getting replaced. And in actuality, you may end up with just 20% of what you were making before. There's a lot of factors that go into it, with one of the biggest being, is your employer providing the benefits for you or are you paying for it? Are they paying for it or are you paying for it? Because if they are,
Tax?
you're taxed on your
Yeah.
benefits and you received a lot less. Some policies require you to exhaust all of the government resources that are out there before your benefits kick in. And so then you may be stuck in litigation trying to get your benefits while you're ill and can't work and your family has no income. You just don't want to be in those positions. And so the first thing I always do with every client is review what they have. Let me tell them exactly what they have first so that they can make educated decisions on whether it makes sense to supplement the plan so that it fits what they're looking to have. The contract language is vital in these plans.
As an employer, you know, you want to give your people benefits and coverage, but you can't possibly tailor that coverage to any of them really to the exclusion of others. So you kind of
Right.
get like a blanket general policy, and it's probably not going to be the best policy because it's expensive as hell and you can't afford it. And to a certain degree, you're just trying to give them some benefit. You're not trying to give them the best benefit.
Perfect example. You being an attorney, you have your own firm, right? But a lot of times, especially in personal injury firms and different stuff like that, the attorneys get a large portion of their compensation from bonuses. And with most group disability plans, the contract will say we're going to cover 60% of your base salary up to $10,000 a month. All right. Well, what if you're making $200,000 a year and 100 of it comes in the form of a year-end bonus? Well, you may be thinking you're getting 10,000 a month, but you're going to be getting $6,000 a month because it's only based on salary. So it's important to look at that. It's important to look at what the caps are. Some group plans are capped at 15,000 a month. Some are capped at 10. And without digging deep and seeing what those are, your plan may not stand the test of things that are going to happen to you along the way.
They may be great. They may be great plans and they may be good for you, but all you're suggesting is just, have it evaluated relative to the client's needs, um, and what the client, thinks they need, and see if it holds up. And if it does, great. If it doesn't, do something about it, right?
Well, a client may be independently wealthy and not needed at all, but that comes down to the point of at what point do you want to transfer the risk elsewhere? And that's why it really needs to be a case, a client by client, individual by individual decision.
Yeah, self-insuring is also an option, but again, like you said, it's a numbers game. Do you want to shift that risk? Is the cost of shifting that risk worth it? Like it's just numbers. It's business. It's
Yeah,
just
exactly.
doing the analysis that was key, right?
If
Understanding.
you want to shift risk or, maybe have a 2-year waiting period where you have independently wealthy, but if you go longer without income for 2 years, you may really start to hurt your wealth. So you can really customize
Right.
it.
Would you agree that you pay for the coverage? You're paying
Yeah.
for it. The more,
You pay
the
for
more,
what you get.
yeah, you do. You pay for what you get, but people don't really know
Most
what they're
people are
getting.
gross And most people grossly overestimate how much these things cost. When you look at percentage of the value of the thing you're protecting, right? I gave this example a lot, and people spend $200 a month on auto insurance for a $40,000 car, but yet if someone even earns $40,000 a year and was going to work 30 years, the value of that income is worth millions of dollars to that person, and yet think the same $200 a month is too expensive to protect the income.
Would you say that the analysis in that respect is like, come up with the window of which you're trying to cover and do the math, and that's X dollars that you're really trying to preserve your right to income, and then just figuring out what that cost is going to be,
Yeah.
and that's the same apples and apples to your analogy of the car, right?
Yeah, and again, with contract language, you can customize the cost based on how you want to customize the plan. You can customize your contract. So it's important to know that.
But you can't just do that, right? Like if you just go on like Esurance, you can't just customize stuff at a high level, right? You can't do that. You have to go through someone like you who actually can work with the insurance company and the underwriters and, you know, go back and forth with them, right?
Yeah, there's a lot of, you can attempt to do it, just like you can attempt to get your legal documents done on LegalZoom. But, first of all, you'll get what you pay for. But secondly, in the insurance world, there's no difference in cost to the client, whether they're using an online service where they don't talk to anyone, or they actually talk to an advisor. It does not change the cost to the client whatsoever.
Right.
It's important for people to know. Most people think that, oh, I'm going to pay for the vehicle and I'm going to pay for your time. No, you don't have to. It doesn't work that way.
So in terms of coverage, not to digress, but relevant to our current environment with COVID, there's a lot of attorneys I know that have kind of shifted their focus to litigating business interruption insurance, which is an insurance I don't think a lot of people had in this environment. They just didn't think about the many ways that it could happen where their business would be shut down, and that loss of income is hurting a lot of people. And the issue is whether or not, and I think we talked about this last time, but the issue is,
Let me guess. I don't think we did, but I'm guessing whether your contract considers something like COVID an act of God or not.
so yeah, so the contract is, the insurance companies are saying, oh, well, this is an act of God, it's not covered. That's too uncertain of an event. Whereas the
Yeah, so
lawyers are
God,
taking
for
the
those
position.
listening, stuff like hurricanes and floods and tornadoes.
Right. The
Yeah.
force it's called force majeure, and there's a long list of things that I think are reasonable to not include because you can't predict them. You can't ensure that. But the attorneys are taking a position that it wasn't the COVID, it was the executive orders. It was legislation. It was
Interesting.
not an act of God because business was continuing as usual until somebody interfered with that by way of government. And so I don't know how that's unfolding, but the point is that there's a lot of insurance. Boy, am I thinking about business interruption insurance right now as something that, fortunately we didn't need, but I got cyber, relatively recently. I'm going to do the business interruption probably, just I'm a big proponent of insuring, risk. Usually it's very, economical to do. So, I noticed, by the way, in terms of getting fired up, you significantly got closer to the camera in discussing number 17, which I think was very illustrative of your passion for that question.
Yeah. It's I don't want to get too personal, but it's something I experienced in my family when someone didn't have the correct language in their clan, and how that ultimately turned out for them. And he's actually okay with me saying this. It was a situation with my father, and you know, things worked out as they should because we're actually a team now and we work together on a lot of things. But not having the correct contract language can be detrimental to someone.
Well, I know your father. I know the story from him personally, and suffice it to say that this stuff has real consequences.
And this is someone who is very financially savvy and still happy. So, take that for what it's worth as well.
It has real consequences if this stuff goes bad, and it can, and all we're really suggesting is just be diligent, you know, look into things, have them evaluated, hire the right people, and make good decisions. Um, the last one I added recently, number 18, it's bold on purpose. It's really important. It's a little bit dated at this point, but I think it's worth talking about because I think that most businesses are completely ignorant of this new rule. And what we're talking about here is the new partnership audit rules. The new partnership audit rules with the IRS. Are you familiar with those?
I'm not. So, I know
All right.
they
So,
I'm going to defer to you, this one on you and get educated myself.
all right. So basically, what happened is that the IRS historically would audit a partnership, limited partnership, LLCs, taxes partnerships, anything taxes a partnership. There's a lot of different kinds. LP, LLP, triple LP, general partnership. There's a lot of kinds. Um, Gotta wrap it up. I have a meeting coming at 5. Forgot about that. So the IRS would historically assess a deficiency in tax at the partnership level, and then they would have to chase the partners. And as you would expect, when you get into sophisticated partnerships, the partners are all made up of different entities who are made up of different entities and who are made up of different entities and so forth. So you really got to get granular and go through a lot of effort to find the inevitable taxpayer that's responsible. So better late than never, they finally wisened up and they said, okay, no more, none of this crap. We're going to assess the partnership at the partnership level, and we're going to collect at the partnership level. We're not going to go find you guys, the partners.
Wow.
Nope.
Okay.
It makes sense given that there's like 4 people working at the IRS right now. At least you thought it was funny. Um, and so basically, they're assessing at the partnership level, they're collecting at the partnership level. And what they did was, it used to be called a tax matters partner. That was the person who was kind of dealing with this in the business. It's usually in an operating agreement that has any quality whatsoever. Now it's called the partnership representative. The partnership representative (PR) is the only person who can talk to the IRS and who can bind the company with the IRS. The only person. So now what happens is you have this person now talking to the IRS. The IRS, maybe they're negotiating, maybe they're not, but there's options that this person has to benefit the partnership, to benefit the other partners who are not in the conversation. They're not allowed to be in the conversation. This person, if they make a deal with the partnership, with the IRS, will in fact affect the partners, and the partners have no representation.
You better pick that person wisely then, huh?
I would say pick them wisely, yes, but I also would say you should build into your agreements this new section that, of course, we've developed, and I have not seen one as good, and a lot of reputable firms I've not seen it as good as mine. Um, we really thought it through. We did a lot of research on it, and we basically developed this provision that says that this person who's responsible for working with the IRS to negotiate and to bind the company and the partners has all these obligations to at least disclose, notify, give all the options available to the partners to maximize their tax benefits. In a sense, there's a lot of elections that they can take
Mhm.
to take it back into their hands, and you want to make sure that you're at least giving those people the right to do that, and that PR has the obligation to do that under our agreements. Whereas if you don't have it, this person literally can be binding these partners in a much more adverse tax position without even them being allowed to be involved in the conversation. So it's a very big change. There's a lot of partnerships that are excluded. There's a lot of partnerships that are not excluded. Grantor trusts, which we do a ton of, are very much relevant here. Um, so that's why I made it, a point to be on top of it. All of our operating agreements that are partnerships will have this in it, almost by default. It's just a matter of massaging the terms. So the new partnership audit rules is important. Um, People don't really understand it. They're ill-equipped to address it because their documents are silent. So hopefully those partnerships aren't even subject to it. But if they are, they should definitely
I'm
look into it.
I'm glad you added to the list because I probably have many clients I need to review and have get their stuff updated.
Yeah, we worked with, CPA firms to really think it through and understand some of those components because like I said, I've not seen a good one in reputable firms. I've seen garbage. Um, so, that's 18 things on our top 10. I've enjoyed going through these with you. Um, I actually added one just now to make it 19 if you're okay with that. Real quick, because you brought it up. Only because you brought it up.
Sure.
Um, and that is employment contracts. We didn't talk about that. We didn't talk about that. And just to be real quick on that, because I know we're going long here. Employment contracts, independent contractor agreements, getting them tightened up so that the agreement with the person in the business is clear. What is this person doing for the business? What are they not doing for the business? Can they bind the business? What do they own? Do they own a piece of the business? You want to prevent them from saying, I'm an owner. You promised me ownership. I've accepted that ownership by working for you. Do they own the materials they create, the work product? Can they compete with the business if they leave? Can they solicit your customers, your staff, your partners, your investors, your vendors? Um, is it confidential what they've learned? Um, and of course, a lot of the legal stuff about if things blow up, how that will be handled. Um, it's just good business to have these things tightened up. Employees expect it, so give them something to sign that is
Because
reasonable.
they probably won't read, but you still should give it to them.
I can't say that I'm happy that they're not reading them, but that is true. Every employee I think expects some type of contract. I've in all my businesses I'm involved in, um, people usually complain about about the terms, um, for one reason or another, and I feel that they're very reasonable. I do. One issue that gets a lot of attention that we kind of talked about relates to transfers when you leave the company. So if you are involved in a company and it's a small company and you leave the company and you're a key person, you're an employee, you're a contractor, whatever you are, even a partner, and you leave, my agreements will say something to the effect that you're entitled to be bought out at the fair market value at that time. That's fair. That's reasonable. Fair market value goes back to valuation. We didn't really get into the many different types of ways that could be done, but the issue that's fine. I don't care about that. What they get tripped up on though is that the buyout period, because there's no insurance at this point, right? It's too small. The buyout structure, the payment structure is that you get a down payment and then you get the rest spread out over a long period of time, usually like 10 years. 10 years. And depending on if you give them good notice or bad notice. If you give them notice like you're supposed to so they can replace you, it's less time, less payout period versus if you don't give them notice and you just quit abruptly, it's hard to replace you, so you get paid out less. It's incentivizing good notice. They always get tripped up on that, but that's reasonable because it limits the financial burden to the business to keep the business going. And that's just an example of how businesses should be thinking.
Yeah,
Do the agreements, do it the right way. I've enjoyed doing this with you.
likewise, likewise. Excited to do another one coming up soon.
We're gonna do more. All right. Well, it's good doing this, and we'll talk soon. All right.
All right, Barry, have a good one.
Bye bye.